Welcome back. So if you're going to law school and on your bar exam or on your LSAT, Marbury versus Madison comes up, the thing to say is judicial review. But point is, Jefferson accepted the idea that the court could review legislation. And the way it works is this. The court does not sit, and Marshall is not saying the court sits in judgment on acts of Congress. He does say it is emphatically the province and duty of the court to say what the law is. And in this case, the law conflicts with the Constitution. In the 1790s, the court had considered the state of Virginia's suit charging that the federal tax on carriages violated the Constitution because the Constitution says the Congress can't impose a direct tax, and Virginia argued that the carriage tax was a direct tax, and the Supreme Court said, well, no, it isn't, really. So if the court can say an act of Congress does not violate the Constitution, that implies, even if you are a Jeffersonian, that it could also say an act of Congress violates the Constitution. So the idea that the court could consider an act of Congress as violating the Constitution wasn't novel. Even Jefferson accepted the idea of judicial review. As you'll recall, his letter to Madison about why there should be a Bill of Rights is because if Congress then violates one of these rights, the aggrieved person can go to court. Okay. However, Jefferson also thought the president had a constitutional role in determining constitutionality. That's why he had a veto. And Congress had a role in determining constitutionality. He also thought state courts could do this. He didn't think the Supreme Court alone had this power. And this is going to be an article of contention. It'll be for Jefferson, it'll be for Jackson, it'll be for other presidents down the road. And incidentally, the court will not overturn an act of Congress again for 54 years. They'll consider lots of state laws as violating the Constitution, but not an act of Congress. And we'll talk about that case later on, a very important one. So Marshall, in this case, is on the surface, he's denying his own power. He can't issue a writ of mandamus. He's actually denying Congress's power to pass a law like this. The law he is attacking, imagine if he had struck down the Judiciary Act of 1802, the one the Republicans had proposed and gotten through Congress and signed into law. That would have been disastrous for the court, but he strikes down a section of the 1789 Act, that never really occurred to anyone else. So it's a brilliant political stroke on Madison's part, or Marshall's part, I'm sorry. Madison never acknowledges that all of this is going on. It's so Marshall knew had he issued a writ of mandamus, Madison would have ignored it. Now, what did the Supreme Court do? It waited for cases to come to it on appeal from the lower courts. The Supreme Court would not hear criminal cases until after the Civil War. The Civil War changes everything. So the business of the Supreme Court is relatively light, which is one reason the Republicans in 1802 could put off the next meeting of the court for a year, because there really wasn't a whole lot for it to do. They heard a lot of cases involving loyalists and their land claims, very complicated cases involving title to land and who had title to land. These very technical cases. When we talk about the great constitutional cases, we're often ignoring the real business of the court. If you look through the reports of the Supreme Court, you'll see in the 1880s, 1890s, there are whole volumes of suits involving patents, patent law, very technical things involving things like the telephone and who really owns the patent to it, and tax law and issues of that nature, which I suppose still take up a lot of the business of the court. These great cases, I think it was Oliver Wendell Holmes, the Supreme Court justice, who said that great cases make bad law. That is, the great colorful cases we're fond of quoting. It's really these mundane cases involving property rights, really technical issues. And we will be talking more about Supreme Court cases as the semester goes on. So don't worry if I haven't talked enough about the court, because the court really begins to find its voice under Marshall. It sits for the first time as a court. It speaks with one voice. and becomes a co-equal branch of government, much to the consternation of President Jefferson, who refers to the twistifications of a crafty chief judge. He doesn't like Marshall and thinks he's too smart a lawyer. Probably, I don't think there's been a time when the president and the chief justice were both probably the best lawyers in the country, and this is one of those periods. As Jefferson was a great lawyer and Marshall had a great legal mind. So both of them, incidentally, had studied under George Wythe, the Virginia legal scholar. Now, before I leave the subject, someone asked about bankruptcy. There was no law of bankruptcy or federal law of bankruptcy at this time. The Republicans didn't want a law of bankruptcy because they thought that would encourage speculation and encourage people to do the kind of reckless things that wind up making you bankrupt, and they didn't want that kind of society, so they blocked an attempt for a federal bankruptcy law. There's a great book on the political economy in the early republic by Drew McCoy called The Elusive Republic, and it's Jeffersonian political economy. I recommend to you. Actually, one interesting case of a guy who goes bankrupt is our old friend James Wilson, the Justice of the Supreme Court. You'll remember the Pennsylvania Federalist is appointed to the court, and his first wife died. He comes to Boston in the 1790s. We'll talk more about him in a couple of weeks when we talk about Fletcher versus Peck. And in church in Boston, his eye is caught, and I apologize for using the passive voice. Karen's probably going to jump up and correct me. His eye is caught by a 15-year-old girl whom he marries. He's now about in his 50s, and he gets involved in this big land deal in Georgia and winds up going bankrupt and actually dies in a flop house in North Carolina fleeing from his creditors, because had they caught him, they would have thrown him in jail. So we'll talk more about James Wilson later on. Anyone here particular fans of Wilson? He's an interesting character, and I think someone should write more about him. Okay. Any other questions? Anyone know any other salacious stories about Supreme Court justices you wanted to share or hear? Okay, good. I apologize to the Wilsonians among you. Okay. Here's another issue for us, getting away from the judiciary, and this is the Mississippi River. In 1801, Spain secretly transferred control of the Mississippi River to France, the whole Louisiana territory. It had belonged to France. After the 7 Years' War, it went to Spain, and then Spain secretly gave it back to France, but the Spanish governor or intendant, still at New Orleans, ran New Orleans. And if you are a farmer in Kentucky or Ohio, these areas into which Americans are moving, what you will do is, load up your hogs or your whiskey onto a flatboat, take it down to New Orleans, and then sell it. And if you get there when markets aren't in season, or you want to get a better price, you're going to wait. And what they did is they had warehouses where you could store your stuff. Now, the Spanish intendant in 1801 said Americans no longer will be able to store their stuff on land in New Orleans. You'll have to wait on the boat. The ideal, actually what you would do when you went down to New Orleans with your flatboat of stuff is sell everything and then walk back, because it's harder to go upriver. So you'd walk back from New Orleans with a lot of cash. Okay, but now, if you go there, you can't get off the boat. It's going to be a big problem. Even if you leave your stuff with an agent, he has to leave it on the boat. So this really is going to hurt American trade, American access to the Mississippi River, which has been a big issue. Back in 1786, John Jay had negotiated a treaty with the Spanish, and he gave up American access to the Mississippi River. And people in the West and the South so much despised this treaty, they rejected it. Congress rejected the Jay-Gardoqui Treaty. So Jefferson realizes if we don't have access to the markets in New Orleans, it's really a bad thing. So he sent some agents off to France to negotiate the purchase of West Florida. or the Florida parishes, this area east and north of the Mississippi River, stretching from roughly from New Orleans to Mobile or Pensacola, which were the only other real Western settlements there. They were trading posts for dealing with the Creek Indians or the Choctaw Indians. So he sends some guys off to France, Robert Livingston, James Monroe, to negotiate for the purchase of this relatively small area of what is today southern Louisiana and Mississippi and Alabama, the Florida parishes as they were called, or West Florida as opposed to East Florida. And they want this for about $10 million, okay? Because it's essential to keep this area. You really need Mobile, Pensacola to give access from Georgia and Alabama to the Gulf. While these guys are negotiating in France with Napoleon's government, Napoleon learns that this army he has sent to Haiti, there's a revolution going on in Haiti. You know, begins during the French Revolution, turns into an uprising of the slaves in Haiti, and Napoleon sends an army to put down this Haitian revolution led by Toussaint Louverture, and the army's led by his brother-in-law, and the army is wiped out by yellow fever and by the rebels, and Napoleon realizes Napoleon's real interest was Haiti, most valuable colony the French had, sugar-producing island, and Napoleon had wanted to reintroduce slavery to it. That wasn't going over well with these former slaves who have freed themselves. So that's why Napoleon sends the army. The army gets wiped out. Napoleon realizes, I can't send another army to put down this revolution in Haiti because Napoleon's about to go to war with England. This is a brief interlude of peace between the English and the French. Napoleon realizes, without Haiti, there's really no point in having New Orleans and all of that territory, you know, because it's pointless. So he says to the Americans, I'll give you all of Louisiana for $15 million. You'll give $11 million to France in gold, and the rest will be credited against American claims. The Americans claim that the French owed them stuff or business deals with the French. So Napoleon needs money to fight the English. So he realizes, okay, the Americans are going to give me $11 million in gold. That will really help fight the English. So let's do it. And these guys know that Napoleon is apt to change his mind quickly, and they realize he'd only been sent to get rights to a very small area. Now he's offering this tremendous territory, really all of the territory drained by the Mississippi River and the Missouri River. So essentially stretching to the Rocky Mountains, an area that the Americans haven't even explored yet. They don't know how vast this is. They don't know what's out there, but Napoleon, it says, it's all yours for $15 million. So Livingston and Monroe say, yes. Okay, they make the treaty, and Livingston says to Monroe, we have lived long. This is the noblest work of our lives. Really quite extraordinary. Livingston had also been on the committee that drafted the Declaration of Independence, and he had been a very important guy. Okay, so treaty comes back from the negotiators by which the United States does not just get this small area of New Orleans, it gets all of the Louisiana territory. Any problems with this? Excuse me? Well, there are people who are already living there. Yeah, that's going to be a problem. You know, the Europeans are French, and they speak a different language, have a different religion. There are also native people out there. We don't know all of the native people out there. Yes? Well, actually, that's a good question. Do the Americans have $11 million? No, but they know where to borrow it. From the British banks, okay? So the British bankers loan them $11 million. They then use that. They pay that to the French. The French then use that to fight the English. So, you know, they can get the $11 million. It's going to hurt this whole idea of paying off the national debt if now you're borrowing $11 million in gold. Yes?
Since this is an international treaty, wouldn't that have to be ratified by Congress?
Well, the Senate has to ratify it, okay? You know, the Senate, the President makes treaties with the advice and consent of the Senate. So yes, the Senate will have to ratify it, which they will, okay? So there's that issue, but President Jefferson, remember, was a strict constructionist. Does the Constitution say that the federal government can, by treaty, buy territory? And then what happens to the territory if it's bought? Is there anything in the Constitution on this?
How did they organize the Ohio?
Well, that already belonged to the United States. That belonged, the states of Virginia and Maryland and New York had ceded their claims to that area. So yeah, that belonged to the United States. And they had Congress had set up governments there, or allowed the people there to set up governments, and they had become states. You know, that's there. But there's nothing in the Constitution that says you can make a treaty buying more territory. Jefferson worries about this because he's a strict constructionist. And he says, why don't we amend the Constitution to give us this power? It's an interesting idea. You know, the Federalists, Alexander Hamilton, incidentally, has gone back to New York, and he starts a newspaper, the New York Post, which he uses to attack the Jefferson administration at every turn. But he says, yeah, buying this is perfectly constitutional. In fact, Hamilton thinks the federal government should be able to do this. It's inherent in sovereignty, just like establishing a bank. Jefferson had thought establishing a bank wasn't constitutional. How could he say buying Louisiana is constitutional? So Jefferson says we should have a constitutional amendment. Madison and Gallatin in the cabinet say, no, we don't need a constitutional amendment because it's going to take a long time to do that. Napoleon is going to think it's ridiculous. We can't take this great deal because we believe in this written document. You know what Napoleon thought about written constitutions. So Jefferson says, well, how about this? A state could annex this territory. So how about if we say the state of Tennessee annexes all of this territory? How about that? Well, they might love that, a big, much bigger territory. Gallatin says, well, under that reasoning, then, you could have Massachusetts annex Cuba, or Rhode Island annex Bengal. You know, that's ridiculous, you know, Tennessee annexing Louisiana. So Jefferson agrees, kind of reluctantly, that, okay, we'll make this treaty buying Louisiana. He regrets it. You know, it's considered one of the great achievements of his administration, but to the end of his life, he really regrets stretching the Constitution to allow the purchase of Louisiana. And then there's another issue. What does happen to these people in Louisiana? Do they become part of the United States? Do they become a state? Can they do that? Who should govern them? The Federalists accepted the idea that the United States could acquire territory, but they don't like the idea that this new territory then can become states on a par with the other states. And they say if this happens, the Union's at an end. If we get Louisiana, it should be treated as a conquered province. The Republicans, on the other hand, think, well, if Louisiana is part of the country, it has to become a state, or states have to be created there that will be on a par with the other states. So by terms of the treaty, the United States has to admit citizens of Louisiana as citizens of the United States on an equal footing, and then what happens is Congress creates a territorial government. The president will appoint a governor and a legislative council of 13 members. Now, the House of Representatives wants to amend this to give the people of Louisiana the power to elect this legislative council, but the Senate rejects that idea. So Louisiana will be a territory with a president and a legislature, or I'm sorry, a governor and a legislature appointed by the president. Fair enough, right? Seeing no objection, yeah, we like this idea of Louisiana, people of Louisiana having the president appoint their...
Very 1776-ish.
Well, it's not very 1776-ish. It's, you know, working out this relationship between, you know, these folks and the government. It's going to take a while. In fact, Louisiana becomes a state in, is it 1812? 1810, 1812, another issue we'll talk about later on. Okay. So Jefferson had wanted a constitutional amendment to cover this. does not get it and somewhat regrets that turn of events. Here's a constitutional amendment they do get. You'll recall in 1800 there had been this understanding between Jefferson and Burr that one was running for president, the other for vice president, and then that had fallen apart. So the Republicans introduce a constitutional amendment so that the electors will vote for two people, one of them for the office of president, the other for the office of vice president. Any objections to this? The Federalists think it's a terrible idea. I think we're working out the whole notion of having an opposition here. And I think the Federalists are going to object to just about anything the administration proposes, ineffectually. Rufus Griswold of Connecticut says, the man voted for as vice president will be selected without any decisive view to his qualifications to administer the government. The office will generally be carried into the market to be exchanged for the votes of some large state for president. The only criterion which will be regarded as a qualification for the office will be the temporary influence of the candidate over the electors of his state. The momentary views of party may perhaps be promoted by such arrangements, but the permanent interests of the country are sacrificed. Right? And Griswold, was a voice crying in the wilderness, says, yes, we adopt the 12th Amendment and no longer have, the candidates for the position carried into the marketplace in exchange for votes of one group or another. Okay, just to let you know what happens in the election of 1804, it's pretty much a cinch that the Republicans aren't going to ask Aaron Burr to be the vice presidential candidate again after 1800 when he said, he couldn't tell Congress not to vote for him. So he is dropped, and George Clinton is the Republican candidate for vice president, the governor of New York, okay, carrying again, you want New York to vote Republican, so Clinton is the man. Clinton, incidentally, serves as vice president under Madison, too, and then dies in office. Okay. Any questions on this? Okay, let's get, yes, sir.
Quick question. I'm not clear what happened with the amendment in Louisiana. So that was not.
They don't amend the Constitution to purchase Louisiana. The United States makes a treaty with France purchasing Louisiana. Jefferson has constitutional qualms, which his cabinet convinces him to ignore. That we can get Louisiana, let's do it, it will be a good thing. Jefferson worries about the precedent this establishes for making the Constitution a blank paper by constructing it, but no constitutional amendment. Later in life, Jefferson says he regrets that maybe they should have, otherwise, had they done that, we wouldn't have had such an expansive federal role in things. Okay, any other questions? Okay, good. Back to the judiciary. Earlier tonight, I talked about this problem for Jefferson of all of these offices being held by Federalists and wanting to create vacancies. And a case comes up in New Hampshire, in Portsmouth, New Hampshire, where sitting on the federal bench is Judge John Pickering, a district court judge. And according to the reports that come back to Washington, reports which actually come from Republicans in New Hampshire, Pickering is an alcoholic. Again, in this period, the average American man drank a quart of whiskey every day. So if we start saying someone drank too much, you're going to exclude most of the people who held public office in this period, in the 19th century. There were some teetotalers we'll get to later on, maybe. But also, he was old and showing signs of dementia, which seemed to be exacerbated when he was presiding over a case which involved Republicans, whom he would berate for their appearance in court. So he's kind of an old, nasty guy. I had a student a number of years ago who wrote a paper clearing Pickering, saying this was all a political frame-up. He was actually really a good, competent judge. But, the report comes back that he is no longer fit to serve as a federal judge. Now, what does the Constitution say about what a judge's term in office will be? It says good behavior. Okay, so he can serve during good behavior. Okay? Is Judge Pickering behaving badly? Is alcoholism and or senility bad behavior? You could argue that, but relative to what? That's a good question. You would argue that. You would say, well, look at you. Not look at you personally. But, yeah. Okay, so if we make the argument he is behaving badly, how do you get him out of office?
Supreme Court?
No. The Constitution talks about how you can remove someone who holds office in the United States, under the United States. Impeachment. Okay. So when there is an impeachment, the House of Representatives will impeach, and then there will be a trial in the Senate of that person. Now, for the president and vice president, it's quite clear what the grounds for impeachment are. And what are they? Well, treason, bribery, or other high crimes or misdemeanors. Okay? Has Judge Pickering committed treason, bribery, or a high crime or misdemeanor? No. I don't think by anyone's definition he's done that. He may have behaved badly. Mr. Soto is insisting that he wants to argue that he behaved badly, and I'll go along with that, even if I think, senility and alcoholism are not something you can control. You're much more of a Puritan than I am, and you think, get this guy out. But, has he behaved badly? Well, maybe, but when you're voting in a court, which the Senate is when it hears a case of impeachment, how do you vote? Has anyone here ever been on a jury? You find the defendant one thing or another. What are they? Guilty or not guilty? Okay. So the senators are a little queasy about saying he is guilty of bad behavior when in fact he is just old and needs to be retired. So the Senate actually does remove Pickering, but instead of voting guilty or not guilty, they vote yes or no. So the clerk says, do you find him guilty? They will say yes. So they don't have to say he's guilty because that implies that he's done something bad when they don't think he has. He's just gotten too old and had too much to drink. So Pickering is removed from the federal bench in New Hampshire. Okay. The same day that the Senate votes on Judge Pickering, the House of Representatives considers has articles of impeachment introduced. John Randolph of Roanoke, the congressman from Virginia, who has become the Republican leader in the House of Representatives, introduces articles of impeachment against Samuel Chase, Associate Justice of the Supreme Court of the United States. And he does this actually after President Jefferson sends him a letter with a newspaper clipping in it. Back during the whole Alien and Sedition Act period, Judge Chase was known as being really tough on Republicans then, on the people who violated the Sedition Act. And in May of 1803, this is just 2 months after the Marbury versus Madison decision, Judge Chase, presiding over a Baltimore grand jury, had given a charge to the jury. In the case, this is when the judge explains to the jury what the law is. Okay? Where law is uncertain, partial, or arbitrary, where justice is not impartially administered to all, where property is insecure, and the person is liable to insult and violence without redress by law, the people are not free, whatever may be their form of government. To this situation, I greatly fear we are fast approaching. The late alteration of the federal judiciary by the abolition of the office of 16 circuit judges, the recent change in our state constitution by establishing universal suffrage, and the further alteration contemplated in our state judiciary will, if adopted, take away all security for personal property and personal liberty. The independence of the national judiciary is already shaken to its foundation, and the virtue of the people alone can restore it. Our Republican Constitution will sink into a mobocracy, the worst of all possible governments. The modern doctrines of our late reformers, that all men in a state of society are entitled to equal rights and equal liberty, have brought this mighty mischief upon us. And I fear it will rapidly progress until peace and order, freedom and property shall be destroyed. What do you think? I don't know what the case was about here, but Judge Chase is clearly unhappy with the way things are going in the country. So why do you think President Jefferson sent this to Congressman Randolph? He wants him to be impeached, yeah. Here's a guy making political speeches to a grand jury in Baltimore. That's not his job. He's, stepping out of line, behaving badly by doing this. So Jefferson suggests having him impeached. And Randolph goes along. The House of Representatives does impeach Judge Chase, Justice Chase, I should say, for making political speeches from the bench, violating or behaving badly. What do you think? Should he be doing this? Attacking the impending mobocracy and these doctrines of our late reformers, changes in the state constitution, the institution of universal suffrage? Yes, Gregorian.
It seems to be, it seems this impeachment is out of line with free speech.
Yeah, but free speech, sure. He's so now you're arguing poor Justice Chase should have the right to free speech. Okay.
I would argue that he's violating the oath of his position, and therefore that would constitute that.
So what's his position?
As a justice of the Supreme Court.
Yeah. So
did he deliver that speech in his capacity as a justice?
As a judge, presiding over a grand jury in Baltimore.
Yeah, he's not being impartial. He's interjecting opinion into what is supposed to be impartial.
Okay, so you would say, yeah. Okay, but who should control? Yes.
Every judge has the potential to have, political ramification whenever
Yeah.
they decide a case.
Yeah.
So I think he's fine. I mean, because there's always going to be a happy person and an unhappy person with any judgment.
Yeah. Okay. Yes.
But isn't he specifically arguing against the laws that are passed in his statement there?
Yeah, he is saying these laws are really bad. They're leading us into mobocracy. Yes.
That's the job of the judicial. We should not have a judicial that just agrees with the executive.
Okay, so the judge should challenge the laws and say these laws really are bad, and I think unless you jurors shape up the virtue, he talks the virtue of the people is the only thing that can save us from this impending mobocracy where everything's going to be in danger. So we have some folks saying he is.
I agree with what he's saying.
Yeah.
That is, for one, as a member of the judicial branch, he's entitled to make this type of comments. That is what he's there for.
Is to criticize laws that are being passed by the political branches.
Whether they're constitutional or not.
But he's not attacking the legality or the constitutionality of the law. He's attacking the political.
Yeah. Okay.
It's not a
Yeah.
legal argument. It's sort of a
Yeah. He's attacking like universal suffrage. This is really a bad thing. And this idea that everyone is equal. Actually, what does he say? Entitled to enjoy equal liberty and equal rights.
may agree with him.
Well, yeah.
I see it from a different perspective, but
Well, by the way, he's saying our late reformers, all men in a state of society are entitled to enjoy equal liberty and equal rights. He says this is nonsense.
I think it's hard to judge it from today's perspective because back then, really not all men were equal, as we said.
But, okay, maybe. But has anyone else in this particular society at this time advanced the idea that all men are created equal? Yeah, Jefferson. Okay, so who do you think he's talking about here? Our late reformers. He's using his address to the grand jury, criticizing the legislature, these constitutional reformers, and the president. Should a judge do this? You're saying no. You're saying yes, it's okay. Anyone else have any thoughts on this? What do you think Jefferson says? Oh, that's fair enough. Co-equal branch of government. He's entitled to his opinion. I believe in free speech. No more reign of the witches. No, he says, let's impeach this guy. Get him off of the court. So Randolph does introduce articles of impeachment into the House of Representatives. Chase, remember, was a signer, bless you, a signer of the Declaration of Independence. He had been a very important political figure in Maryland. And so he's no lightweight. He also is able to get a very good lawyer to defend him in the Senate. His lawyer is Luther Martin. You may remember from all of our discussions of the Constitutional Convention and ratification, Martin and Chase both had been real anti-federalists in 1787-88. Then they both became staunch Federalists, which is how Samuel Chase winds up on the Supreme Court, appointed by President Washington, and Martin becomes known as the bulldog of federalism. We'll talk more about him later on. And Chase and Martin successfully defend Chase against the impeachment, although more than half of the senators vote to remove him. But in order to be removed, you need a 2/3 vote. So Chase stays on the court. He's acquitted. What happened here? Jefferson really lost interest in the case. Now think about the consequences had Chase been removed, had the Senate convicted him. Do you think the Jefferson administration would have lost interest in opening up vacancies on the court through impeachment? And Marshall was pretty sure who was going to be next if Chase gets impeached and removed. And then you can think about the consequences for the country over the next 200 years. Had presidents and Congress used the power of impeachment to remove judges they didn't like to open up vacancies. So Chase stays, even though you and I both think he was out of line and probably would have voted to remove him. In the long run, that's a good thing. So, I regret we don't have time to talk about all the other interesting things that happened in the Jefferson administration, so we'll have to come back next week to find out what else happens during this exciting 8 years. Are there any questions before we end? Okay, so I'll see you all next week.